lots of things that mostly came out of the Avon litigation, but we'll be focusing really on the key decision from the hostile part of the, hostile part of that case, which is the examination of best trustees and the old Hastings Bass guidance on severance. So, just to paint the picture, this litigation is about a benefit design change, which was designed to save the principal employer of the scheme money, because that's what it wanted to do, avoid, in a legal sense, appropriately avoid some of its final salary liabilities and de-risk its pension liabilities for the future. So in 2006, it changed the basis of accrual from final salary to career average, and it did that not only for future service but also for past service, despite the fact that it had a courage type fetter. Courage type fetter is still a phrase that we can use with complete safety, despite the recent decision in the case of Newell. And there was advice given to both the employer and the trustees, very detailed advice, particularly on one side, but at no stage was there any mention of courage or any risk arising from the fetter. The parties in this part of the litigation, so Avon Cosmetics, who was represented by Lydia Seymour and myself, instructed by Eversham Sutherland, the representative beneficiary, who were represented by Keith Bryant and Naomi, instructed by Penningtons, and the professional trustee, who were represented with genial neutrality by Paul Newman, QC, at the hearings. So there are two judgments, and I'm going to talk about the second one there first. Let me explain who final salary winners are and who revaluation winners are. So, the old final salary benefits that were final salary benefits up until the point in 2006 when the amendment was made, were treated thereafter as deferred benefits. So they were subject to statutory revaluation but no longer linked to final salary. Now that always used to be bad news. I think one thinks about all the cases that existed, certainly from Courage. It was terrible news for people in Courage because there wasn't any requirement for statutory revaluation then, so they really lost out, which probably explained why Mr. Justice Millett was so upset about what had been done in that case. It used to be the case that final salary benefits were thought of as the gold standard. However, in our case, a significant minority of members had actually gained more valuable benefits by losing their final salary link for their past service and being given statutory revaluation instead. As you can imagine, it's obviously dependent on various things, for example, promotions and salary rises and so on, as opposed to the continuous effect of the link to revaluation. So we had a situation in which, on authority, the amendment had failed insofar as it affected the past service benefit, or probably failed insofar as it affected the past service benefit. But some of the people who were so affected had ended up with more valuable benefits than they would otherwise have done. They were the revaluation winners, because revaluation had been better for them than their old final salary link would have been. The final salary winners, you will be most unsurprised to learn, are the people who would have done better if they retained their final salary link. At the background, I mentioned the professional advisors who had advised on the amendment. At the background to these Part 8 proceedings are Part 7 proceedings. Initially, the tactic that Avon had decided upon advice was to try and negotiate a compromise in relation to the final salary link issue. So in other words, gain some benefit from its own perspective for the failure of the amendment to affect past service benefits, and therefore limit the amount of the additional liability that was created by the final salary benefit that had been lost, being reinstated. But well into that strategy, and I think I'm right in saying the compromise had been agreed, or almost completely agreed, solicitors acting for the Part 7 defendants insisted that, on the basis of a case called Wedgwood and Salt, the assumption that we had made, which is that the revaluation winners still got their full revaluation benefits, they had benefited from the amendment, no harm done, that should be raised in litigation as well. I've covered the top part of that. That was the fetter. In any way which affects prejudicially benefits accrued or secured up to the date on which the amendment takes effect. So just to be copper bottomed, it's accrued or secured. You may remember some of the Courage litigation. For a long time it was thought that secured was the magic word, but then after the decision of Mr. Justice Ling Leeds, accrued was given the same effect. So both words protecting the final salary link. So I think I've given that in summary form, and as the slide says, the questions before the court in the course of the two hearings was, did the 2006 amendment engage the fetter? In other words, did it butt up against the fetter? Was the fetter something which caused a problem for the amendment, such that it would be invalid for the final salary winners? And if so, was it nonetheless valid in respect of the valuation winners? Now, there have been numerous cases, some of which are reported, some of which are compromises and therefore have not been reported, in which comparable results to amendments such as this, in which some people, despite the fact that the final salary link was taken away against the protection of a Courage fetter, some members have done better, in which it has been consistently accepted that the people that nonetheless have been lucky and have benefited from the amendment, that they keep their better benefits. It's fair to say that has always been the assumption. And to the extent that the reason for that assumption has ever been articulated, it's always been on the basis of a decision of Mr. Justice Neuberger in Best Trustees. Now, in the revaluation winners hearing, which was the hearing to decide whether or not the revaluation winners kept their better benefits, we ran two arguments, one of which is libelously described as the magic wand approach. Naomi drafted that slide. But is in fact the equitable remedy on terms approach, which of course is much more dignified, was based on quite a well-known, well, a case that used to be quite well-known, but has since sort of fallen slightly out of interest, even amongst pensions people, Doyle and Manchester Evening News, Better Fence and Vase, a decision of Mr. Justice Lightman, and IMG Pension Plan, a decision of Mr. Justice Arnold. And broadly speaking, what this argument, if it's a valid argument, what it says is that you, as a judge, examining the result of an exercise of an equitable fiduciary power, can provide a remedy on terms which changes the result, preserving what was lawful insofar as he or she can, albeit not being able to rescue the unlawful part of the amendment. And so here the unlawful part was the removing of the final salary link for people who would have done better if they'd been able to retain it, and the allegedly lawful part was the giving of the revaluation benefit, even though it was thought by everybody at the time that that would save money, the giving of the revaluation benefit to members who turned out to do better as a result of that. So we said a classic case, just hear us saying it, called a classic case, for the application of the, nothing to look at, not the magic wand approach, the equitable remedy on terms approach. Then secondly, there is the severance. Now if that was correct, the upper argument was correct, we were, not we, but Avon were home free in terms of the argument they were trying to sustain. But it was into severance that one got into slightly murkier water, in the sense of more legally convoluted water, because there was there was a dispute. Again, this has been drafted by counsel for the representative beneficiary. Lots of cases against some decision called Pitt and Holt. Pitt and Holt, of course, in the Supreme Court, although, to be fair, heavily reliant in a not particularly helpful way in the judgment on the decision of Lord Justice Lloyd in the Court of Appeal, as against Best Trustees and Stewart, the primary authority, Wedgwood and Salt, the decision of Penelope Reed, KC, sitting as High Court judge, which is the one that the defendants had focused on in saying, hang on a minute, Best Trustees, you can't actually give these people their benefits. The point being, of course, that it considerably increased the quantum of the profit rent claim if the revaluation winners were entitled to their full whack. And IBM in the Court of Appeal, a difficult and very uncertain, almost certainly not part of the ratio of the case, bit of Lord Justice Lloyd's judgment. That's not how Naomi would put it. Now, we heard reference in a discussion earlier to the fact that the High Court bench is now populated by judges who have no idea what commercial pension schemes are or why they matter, and really doesn't see what all the fuss has been about in the sort of 90 or so cases that have been generated, even while they've been on the bench. Because Sarah Ashburn, Chris Nugent, and other people have betrayed us by going to the Court of Appeal. Self, as I've mentioned. And it means and the judge in this case, excellent and sensible judge, Malcolm Davis White, KC, sitting as a High Court judge, is an example of judges that didn't know very much about pension schemes before the start of the case. And there are other examples, but focused on anybody in particular, who I wouldn't describe quite such a complimentary way as is on Judge Malcolm Davis White. But for their part, I think in this argument on severance, so Keith and Naomi's argument was to try and uphold to say that Best Trustees is a very highly respected authority, which of course it is. The authority was a decision of Mr. Justice Neuberger, who was only a High Court judge then, of course went on to be President of the Supreme Court. And why, on what basis can it be effectively set aside? And I think it's fair to say that Keith and Naomi first realised that the tide was running against them when the submission was made to the judge that Best Trustees was a decision of Mr. Justice Neuberger, and the response from the judge was, so what? He's a High Court judge, I'm exercising the jurisdiction of a High Court judge. So you know that you're in for an uphill struggle when that's the first response you get. So the test in Best Trustees was twofold. Can you physically sever the good from the bad, the legal from the illegal, if you like? That's limb one. And typically, cases about severance don't have a problem with that element of the test. But the second element, which is the one that's had I think probably been overlooked in quite a lot of cases, was are you satisfied as well that if they'd known the true position, in other words, that they couldn't get rid of the final salary link, the trustees would have done the same thing. Now, it wasn't meaningful in Best Trustees because Best Trustees was an equalisation case, and it was obvious that the trustees wanted to equalise, they had to equalise benefits, they'd been told that they had to, they tried to do it retrospectively. They were told they couldn't do it retrospectively, but obviously they wanted to do it from as early a date as they possibly could. So if they knew they couldn't do it retrospectively, they would still have done it as from the date of the deed. So this second limb of the test didn't really feature as an interesting or significant part of the Best Trustees decision. But in cases like this one, final salary amendment cases, it's not really the same thing, because as was pointed out against us, quite rightly, the intention wasn't to give revaluation winners better benefits by keeping them on a revaluation basis. The intention was to save money. And these people had done far better than they would otherwise have done. So it was contrary to the intention. So why on earth, since what the employer wanted to do at the time, took actuarial advice and had a raft of options as to changes that could be made which would de-risk, surely what it really had done is chosen one of the other options for de-risking. However, what the judge found, and it's fair to say, absolutely fair to say, there's some support for the suggestion that that is a part of the test in the Wedgwood and Salt case and in the not part of the ratio of the case bit of IBM Court of Appeal. But our case was that you have to understand what Mr. Justice Neuberger decided in Best Trustees on the basis of the then test as it was understood in Hastings Bass. Now, when Best Trustees was decided at the beginning of this century, nobody had, well, people were only just beginning to wake up to the fact that something had gone a bit wrong with Hastings Bass, in the sense that it had been run with. And it was still thought at the time that Lord Justice Buckley's statement in that case, in which he said, in fact, this is the ratio of my decision, then set it out, wasn't in fact, silly old Lord Justice Buckley, the ratio's decision at all, but was another part of the case which the Supreme Court and the Court of Appeal in Pidenholt identified as the correct ratio for Hastings Bass. The problem being that Hastings Bass had been used in lots of mistake cases. You may remember in the good or bad, depending on which side of the line you were on, old days, people would seek rectification. They would seek, as somebody used to say, to Hastings Bass something, which meant to achieve the same thing as rectification without those nasty high evidential hurdles. Or they lob in voluntary rescission on the basis of another decision, like Kerridge and Mr. Justice Millett, in a case called Gibbon and Mitchell. High Court decision, ex-tempore judgment, hugely influential, until it was quite graciously kicked into touch by the Supreme Court in Pidenholt. We said, you have to re-understand Hastings Bass. The Supreme Court tells us that you can't still understand the ratio in Hastings Bass to be what it was thought to be in 2000. That being the case, the second limb is no longer part of the ratio, which is what the Supreme Court said. That being the case, there's no proper way in which you could enforce the second limb and say it was a requirement before you can sever. All you need is that the amendment is consistent with the purposes of the trust. And that's, if you haven't got that in the pension scheme amendment, then you really have them badly wrong. So that wasn't a problem in our case. The decision, the problem, if you like, with the case, the only problem from our perspective, there are other problems from the point of view of Keith and Naomi, obviously, in terms of the result, but they act for the representative beneficiary, they had to argue the case that they were given, and so it's the nature of the beast when you're a rep there. Is that because, well actually I don't really know why, but for some reason the judge decided to explain his reasoning by reference to a lot of public law and commercial contract cases, none of which were cited to him by either side, by any of the parties, or in any of the Skeleton arguments. I think he actually referred to more cases that weren't in the Skeleton arguments than cases that were. And in my humble opinion, it serves to obscure the reasoning, not to illuminate it. Because there were two, it's pretty apparent, not often when you start to read a judgment, that you can't tell the way it's going. I had to flick right to the end to find out whether we'd won or not, and then go back to try and understand how he'd reached the bit that he got to at the end. It seems that he decided on the basis of the equitable remedy on terms approach. In other words, you can save the good. A judge can look at it and say, no, the bad fails, but you can save the good, so the revaluation winner's beneficial amendment is saved. And it also seems that he decided on a severance basis as well that you don't need to apply the secondary element of the test in best trustees, but you really have to work hard to try and find that amongst the wealth of fascinating, in a neutral sense, but not obviously useful in a specific sense, expert rumination on these non-pensions cases. Now, I'm all for, and we all do it where it helps us, using non-pensions cases to support arguments that you want to make to the court, particularly if you're looking to find a result which isn't perhaps fully supported by any of the existing pensions authorities. It's what we all do. But it's a different thing where the judge decides to do it and nobody of the parties decide to do it for reasons which don't appear to assist with the result. And it makes the judgment quite difficult to read. That's the one of the key bits from the Walker's judgment in Hitchcock. There were many other points, and it's part and parcel of cases that are heard, the unusual features of cases, the way that they work, the Wedgwood and Salt Authority, in which the defendant are relying on to get us to raise this case, was a case in which the issue, this particular issue, had only been sort of born in argument during the actual hearing of the original case. It wasn't one of the issues on the original claim form. There was an adjournment to allow counsel to prepare written submissions on this point, so it was done as a bit of an insert. It was done in a bit of a hurry. A lot of the relevant, in fact, pretty much all of the relevant bits of the Supreme Court, we've been told, weren't cited to the judge, so she didn't have sight of that. So it is the case that we sometimes have to deal with authorities, and of course when it suits you, you pluck the relevant paragraph or the relevant sentence and sort of say, ta-da, and then you don't necessarily go to too much trouble to explain the context to a judge if it doesn't help you. And it can lead to, not perverse, but some quite surprising decisions. I'll now hand it to Naomi. Thank you very much.
Good afternoon, everyone. So picking up from where Richard left off, a lengthy judgment, but I think what it really boiled down to was that the judge said on the one hand, well, am I going to ask what was the substantial exercise of the power, and is the part to be saved the same exercise of the power, which is a test sort of drawn from public law, or am I going to ask what would the trustees have done had they known that the fetter prevented what they were actually trying to do, which I analyse as a subjective exercise of the power. It's going to involve my looking at the subjective intention of the trustees, and he preferred the first because he felt that there were evidential issues looking into the minds of the trustees. It was a hypothetical question. The trustees might not have been that engaged in the first place, and quite often the honest answer from the trustees who were in place at the time might well have been, I'm not sure, I'd probably have had another think, taken some other advice. So there's no doubt that to adopt the approach that the judge took simplifies the task. It's a kind of becomes much more of a construction exercise. What was the purpose that the trustees were trying to achieve? The judge also felt that if he adopted this purpose test, that he'd be more in keeping with the way in which judges had tended to approach questions of severance in a public law or a contract law context, and I'll come on to talk about that a bit more in a second. And secondly, of course, if you are applying the test of what would the trustees have done in this particular context, you're left with a lot of very unhappy employees who thought they were getting their pensions revalued every year. You know, after 2023, what a blessing in disguise it was to have your final salary link severed, and all of a sudden they're stuck with, you know, whatever dreadful pay rises they got in the interim period. So obviously that's why the company, perhaps contrary to what one might otherwise have expected, was arguing that they had these obligations towards those who were better off as a result of the final salary link have been severed. And so that was the outcome. The company applied for or sought an order that the revaluation winners should get the benefits that they thought they were going to get. And I can completely understand that that was the attractive outcome. It was the outcome that protected the interests of people who would otherwise have been disadvantaged by an error that had nothing to do with them. But on the other hand, I do think there are some significant criticisms that can be made of the judge's reasoning, and that might cause different issues when applied in a different context, where the implications of severance are different. So the first point that I'd like to make is that in drawing as heavily as he did in contract law and public law, and ultimately applying the test that was derived from those cases, the judge ignored the comment of Lord Justice Mummery in the Court of Appeal in Pitt and Holt, which was endorsed by Lord Walker in the Supreme Court, that analogies with public law were unhelpful and unnecessary. Lord Justice Mummery had said, you've got to think about, the control of the courts is for the purpose of ensuring that public laws are acting within the limits of their statutory powers. Whereas he went on to say that the limits of trusts law controls the exercise of the powers that are conferred upon fiduciaries for the benefit of members within a designated class. Similarly, in contract law, the question that the court asks is, well, you've got two contracting parties entirely free to contract, no fetter on what they can agree to except for what is contrary to public policy. The court isn't interested in what was their intention, just interested in what elements of their bargain can be saved. Whereas in trust law, in classic trust law, you're looking at distributing the benefits of a limited trust fund amongst your beneficiaries. And in pensions law, you're not just doing that, of course, because you've got the employer standing behind the scheme. You don't have a sort of finite pot in that sense, but the trustees are always considering the interests of the employer alongside the interests of the beneficiary. And so the distinctions that arise between these different areas of law, I would suggest, and I'm sure that the representative beneficiary would have said, had this ever come up in discussion in the High Court, that perhaps there are reasons for different approaches to be taken in different areas of law. And the approach taken by the judge rather glosses over those reasons. So that's the first criticism that I would make. The second criticism is the gloss that the judge placed on the question of what would the trustees have done, which the judge understood to be a purely subjective question, looking as a matter of fact at what those trustees in that scenario would have done. But that's not the way in which the Supreme Court characterised the question of what would the trustees have done in Pitt and Holt, albeit that it was critical of the sort of subjective approach that the judge rejected. Following Pitt and Holt, where you have a trustee body which fails to ask itself the relevant question in a manner or to the extent that that is a breach of fiduciary duty, its decision will still be set aside. And in those questions, in those circumstances, the court will still need to ask, what would the trustees have done, albeit that that question is framed as an objective question. What would a reasonable trustee ward have done in these particular situations? And that, of course, does permit the drawing of extrinsic evidence to identify the purpose for which the trustees were acting and the interests which they intended to advance. So in the current case of Avon against Dalriada Trustees, the purpose of the amendment, of course, was, as Richard said, to reduce the cost of the scheme for the company. But the impact of the judgment is that the company not only has to fund more expensive benefits than it thought it was funding for FS winners, but also for revaluation winners. It's the most expensive option, and from the company's point of view, it's the worst of both worlds. The judge concluded that the substantial purpose of the original amendment and the benefit redesign was to remove the FS link and to link pensions to revaluation. Well, that is what was done. Was it why it was done, or the purpose for which it was done? Of course, the word purpose can have a very broad meaning, it can have a narrower meaning. That wasn't a debate that the judge got into in his reasoning, but it was the reversal of what the trustees had been trying to achieve. So the outcome of Avon is a very pragmatic one from the point of view of employee relations and in terms of the rights of the beneficiaries. But it is not such a pragmatic one if you're a trustee or an employer, and it possibly, arguably, moves away from the idea of what the fundamental role of the trustee is and how that